Kenneth Obina.
Yes, Kenneth is in class.
All right. Bakari Zainab.
Yes, good afternoon.
Good afternoon. Temitope Toyin. Temitope Toyin.
Yes, good afternoon.
Good afternoon. Latifat Mustafa.
Good afternoon, I'm here.
Good afternoon. Then we have Aideloje Efe Corazon.
Yeah, I'm present. Good afternoon.
Okay, good afternoon. So it's just Blessing that is not in class. Yes, sir.
So how many?
Sir?
How many people are not? How many of the presenters are not there?
Just one, sir.
Anyway, you've taken note of the.
Yes, sir. I've taken note of that, sir.
Okay, who is presenting among them?
I
There
guess
are
they'll have to
three.
let us know. All right.
Yes, we are three. We split it into three parts. We are going to present based on parts, sir.
Okay, let's go on.
Yes, sir.
First part.
So our topic is marriage in the conflict of laws of Nigeria. Our seminar paper is in 5 parts. Yes, so our abstract. In our abstract, we discussed that the pluralistic nature of the Nigerian legal system often occasions conflicts in the laws due to the applicability of the statutory, customary, and Islamic laws. And in our paper, we have examined internal and international dimensions of conflict in marriage and identified key areas, including the validity of marriage, jurisdictional issues, recognition issues, and conflict between different marriage regimes within Nigeria. In doing so, we analyzed relevant case law, statutes, and judicial responses to conflict. And we also drawed comparative insight from the United Kingdom approach to marriage conflicts. So now part 1, we have the concept of marriage in conflict of laws. Yes, so we evaluated the Matrimonial Causes Act and the Marriage Act, and we identified the gaps in addressing contemporary challenges such as polygamy, monogamy disputes, jurisdictional ambiguities in state high courts, and limping marriage. Yeah, so starting with customary law, the Court of Appeal in case of Inserim and Inserim posited that customary law implies the habitual practice and course of action, which is characteristically repeated in like circumstances. Similarly, in Lewis and Bankole, it was said to be flexible in nature with an unquestionable adaptability to alter circumstances. There are essential factors that are necessary for the validity of. We briefly looked at the requirements for customary law in Nigeria before it can be deemed to be valid, which are the age. There is no fixed minimum age of marriage. However, it is widely accepted that it's the attainment of puberty. Although in the eastern part of Nigeria, it is said to be 16 years. That's the minimum age. Then there's the parental consent by the father or the guardian who is in locus parentis. Then the consent of the intending spouses, the payment of dowry.
This is a conflict of law class, not a family law class now. Do you understand?
Yes, I understand.
It's a conflict of law class. We are not interested in all those details of features of customary law marriages. We are
Yes, sir.
interested in conflict. In conflict. Hmm?
Yes, sir.
Conflict of laws. Conflict
Yeah.
of marriage laws, not marriage laws, not Nigerian marriage laws. I hope. Unfortunately, I don't have your paper. Can you send the paper to my WhatsApp now so that I can look at it and guide you on what to present?
Yes, sir. We sent it to the WhatsApp. It's on the WhatsApp group, sir. So
When?
we sent it yesterday, sir,
Okay,
to the
okay,
WhatsApp.
okay.
Yes,
Okay,
sir.
your
I
class
just
captain
sent
has
it
sent
to
it
you.
to me now.
Yes,
Okay,
sir.
sir. So we move to the conflicts arising from Nigeria pluralistic.
Wait, let me open your paper so that I can guide you on the presentation. We don't have much time. I will just look at it and see where you said what is relevant to our purpose and tell you to read it or explain it.
Okay, sir.
See, I cannot download this document because it is no longer on my phone. What's the meaning of that? You just sent it now, isn't it? Why is it telling me that it's no longer on my phone?
I just sent it, sir. Let me resend it.
Wait. Maybe I... Oh, okay. This is it's not today's zone. Okay, sorry. I will open it now.
Okay, sir.
I'm going through your table of contents.
Yes, sir.
Photo, let's see what you said on part 2. Internal
Okay.
conflict in Nigerian marriage laws. What did you
Okay,
say
sir.
there?
Okay, sir. So part 2, internal conflicts in Nigerian marriage laws. The conflicts between Islamic law and statutory law, we discussed the issue of polygamy versus monogamy. We cited, for instance, the case of Eid and Eid, where the court described marriage as the voluntary union. So in that case, a petitioner who was previously a Mormon renounced his faith and then contracted another marriage in a country where polygamy is lawful. In that case, the court held that marriage between individuals of a faith allowing polygamy is not recognized as valid by English courts in matrimonial suits, even if the marriage is valid under local law and both parties are single and competent to contract at the time. Also, in Nigeria, there is the provision that no marriage is valid when either of the parties had been married before the celebration of the marriage, except if it's to the person that they're getting married to. And this contrasts with Islamic law, which permits polygamy, allowing a man to marry up to 4 wives under prescribed conditions. We also looked at the case of Al-Rahman, where a man who had previously married under the Act contracted another one under Islamic law, and the court said that he was guilty of bigamy and held that that marriage was void. The same thing in our Prince, where a Christian subsequently became a Muslim and contracted a marriage under Islamic law with another woman, while the previous marriage was still subsisting. The court held that the marriage was invalid. Yes. There's also conflict when it comes to dissolution of statutory marriage, where for instance, for statutory marriage, there's only one ground for the dissolution of marriage, which is the irretrievably breakdown of the marriage, provided it is any of the facts in section 15(2)(a) to H of the Act has been proved. However, Islamic law recognizes 4 types of divorce, can be in various forms. So we also looked at the customary law and statutory conflicts, where in some circumstances, for instance, the Child Rights Act provides that no parent or any other person can betroth a child to any person, as such betrothal is null and void, which is contrary to customary law, where there's sometimes betrothal is prevalent. Also in the eastern parts and like the Ishon native community, where there's a customary law customary practice that allows a woman to marry another woman to raise children together. This contradicts the statutory marriage principles, as only marriages between a man and a woman are recognized as valid in Nigeria. Additionally, customary law.
My sister, did you
Yes, sir.
just join us? When do we say we have a conflict of laws? What is the definition of a conflict of law situation?
Yes, sir. That's when there's like a conflict in the choice of law and the personal law which someone is subjected to.
You see, there's a difference between conflict of laws and comparative law. Comparative law simply means you are taking 2 systems of law, researching their internal features and comparing their internal features. That's comparative law. It's not the same as conflict of laws. Conflict of laws is where you have a dispute between A and B. Okay? And that dispute is capable of being governed by more than one system of law. And the conflict of laws is the one that dictates to you the one that would apply. And we said that in Nigeria, conflict of laws has 3 dimensions. The international dimension, in which case the connection is with another country of the world. The foreign element is another country of the world. Interstate, in which case the foreign element is another constituent state of the federation. And internal, or what we call legal pluralism, in which case the problem that the court is facing is how to determine which of more than one system of law applicable on a subject will govern that dispute. Do you understand?
Yes, sir.
So what we are concerned with in this class is what are the dimensions that conflict of marriage law can throw up. Okay, conflict of marriage law, what dimension of the 3, out of the 3 dimensions of conflict that we have mentioned, which ones are possible, which ones are not possible? Okay, so international dimension is possible because it is possible for somebody who has submitted an issue pertaining to his marriage to our court to demonstrate that either that marriage was celebrated abroad or that the parties or one of them is domiciled abroad. When that happens, there is a foreign dimension. But there is an interstate dimension is not possible Anybody tell me the reason why interstate dimension of conflict of laws in the area of marriage is not available in Nigeria? Can somebody tell me the reason for that?
Yes. Good afternoon, Prof.
Good afternoon.
Yes, my name is Kenneth Oki. I'm a member of Group 8. So the reason why interstate dimension in the area of conflict of laws, that's marriages, is not possible in Nigeria is that by virtue of our Marriage Act. So marriage domicile in Nigeria is taken as a one entity when it comes to domicile and then jurisdiction. So the Marriage Act in Nigeria applies to the entire country as a whole.
Only
So
the Marriage Act. What of the Matrimonial Causes Act?
Even the same thing with the Matrimonial Causes Act.
So
that
all
someone,
the statutes of marriage in Nigeria are national statutes.
yes, sir.
They are national statutes enacted by National Assembly. So you
Yes, sir.
cannot say because your own marriage was done in Oyo, it would be different from the one that was done in Lagos. You
Yes,
cannot
sir.
say because you live in Oyo, because the issue of dissolution of your marriage will be governed by a different law from the person who lives in Sapele. So for that reason, there is no interstate dimension. So the third dimension is internal. Do we have internal dimension? Do we have internal conflict of laws in the area of marriage? First of all, let somebody define for us what is internal conflict of laws or legal pluralism. What is it? When does it happen? You see, all of these things, we've received lecture on them before. Somebody has presented on the dimensions of conflict of laws. But I know that people do not grasp the distinction until when you come to the nitty-gritty like this. Why do we say that apart from international dimension of conflict, there can also be internal dimension of it in the area of marriage?
Yes, Prof, good afternoon once again.
Good afternoon.
This is Kenneth Oki from the same Group 8.
Yes.
Yes, when we talk about the internal dimension of the conflict of law, it's possible in a situation in like Nigeria where we have pluralistic system of laws. For instance, we have different customary laws in place, which varies from place to place. For instance, in the Igbo part of the country, they have their own system of laws when it comes to marriage, different from what obtains in the Southwest. The North has its own. So in the internal conflicts of laws is possible in the area of marriage, in the sense that someone who is married is just to a limited extent anyway, because all the customary systems in Nigeria recognize polygamy. So that being the case, in that sense, there is no conflict. Being that
Sir,
whether
Sir, you are struggling for a simple matter. The reason why we have internal conflict of law is straightforward. The reason is that you have more than one system of marriage laws operating in every state in Nigeria. And because it's not a question of foreign element. It's not because you are not saying that the court is confused as to which law to apply because somebody is a Togolese or a national of Togo. Both A and B are equally amenable to the law of statewide. But it is quite possible that within that statewide, A is governed by one customary law and B is governed by another. It is possible that A is governed by one customary law and B is governed by a religious law. Okay? It is possible that A has put up conduct that shows that his marriage is governed by the federal laws, that is the monogamous marriage laws, whereas B is governed by, or B wants to be governed by customary law. So because there are more than one system of law applicable within the same territory, the result is that if you say marriage, somebody will ask the question further, which type of marriage? Somebody who does not know conflict of laws will tend to match the marriage together and say that one is superior to another. It's not a question of superiority. You cannot say that the man who does customary marriage has not married under Nigerian law. And you cannot say that the man who does a nikah in the mosque has not married. So, as far as he is concerned, he has married under Nigerian law. Okay, so because in every state you have a minimum of 2 or 3 system of marriage laws, and everything depends on the choice of the parties. For that reason, you could have a problem of internal conflict. Okay, the highlight of internal conflict is that whereas interstate and international will usually throw up geographical issues. Okay, internal does not throw any geographical issue. It's not the reason why the court will face the task of determining applicable law. It's not necessarily because one party is from another place, but because within that same state, more than one system of law is allowed. So that is why we normally say that the dimension of conflict of laws in the area of marriage in Nigeria can be either internal or international. When is it internal and when it is international? When is it internal? When is it international? Our courts and our experts from other subject areas, they need to understand that. It is not internal if there is a foreign element. It is international if there is a foreign element. So when the issue becomes the issue of somebody being domiciled in another country or being a national of another country, which is the reason why you are reconsidering whether the marriage is valid or not, or whether a particular law to have governed the marriage or not, that cannot be an internal conflict issue. It must be an international dimension of the issue. And in this course, to point out very common errors, we will use the case of Fonseca and Passman. I think we've discussed Fonseca and Passman in this class before. Hello?
Yes, sir, we have.
And even if we have not discussed it, you all must have come across it in your Nigerian legal system. You see legal system text writer, they call it the marriage cases. They discuss the case, but the only thing lacking is understanding of the dimensions of conflict of laws. Bringing that case under internal conflict is misunderstanding conflict of laws. A matter is not internal conflict of Nigerian law simply because the case came on before Nigerian court. If the case came on, or if the case was decided by Nigerian court, but there is an obvious foreign element, it cannot be internal conflict. In Fonseca and Passman, the husband was a Portuguese, presumably domiciled in Portugal. The question was whether the wife or her children by him could inherit the deceased husband. Okay? And What did the Nigerian court do? The Nigerian court, finding no black and white answer, okay, they just concluded that there are provisions in the customary law court's personal jurisdiction, which says that the customary court can only entertain jurisdiction where where natives are involved. You will see the definition of personal jurisdiction of the customary court or an area court. They will say if the dispute is between a Nigerian or a native, depending on which state you are looking at it, okay? And they will then define who is the native. Some of them will say it extends to people of African descent, and all of that and all of that. So the court, in that case, simply arrived at the conclusion they simply disinherited that woman because of the provisions of the customary courts or area courts law that prescribe personal jurisdiction of the area court. But you see, it's a mistake that everybody makes in this country. It's a mistake. For me, it looks like an elementary error. I don't know why I call it an elementary error. There is no dispute. There is no dispute that the court would avoid hearing simply because a particular court has not been assigned to hear it. The reason why those type of arguments are elementary wrong is because there is one court that is a court of unlimited jurisdiction. And that court is the State High Court. So if the customary and area court law says only natives can come before this court, that may be correct to say you can't go to customary court. But it is not correct to say that customary law cannot apply. What is our problem? There is a distinction between applicable law and jurisdiction of a court. Jurisdiction of courts are determined on subject matter basis. So, an inheritance matter, who says that because what the court is likely to apply to the inheritance matter is customary law, therefore, the High Court of Justice will not be able to entertain it. How many people are following me?
Okay.
So, in Fonseca and Passman, the judge misapplied the provisions of the customary court law that said that the personal jurisdiction of the court is limited to natives. He mistook that one for an assumption that a marriage relationship between a foreigner in Nigeria and a native done under customary law must be null and void. That is a grave error. The judge was not even motivated by the fact that the judgment is given is going to put a Nigerian citizen in jeopardy. That didn't concern them. They thought they were doing the right thing, but they were elementarily wrong. The case was in the High Court, and there is nothing that says the High Court cannot apply customary law if customary law is the applicable law. Did we not? Is it not there in the High Court laws that the High Court should apply customary law, which is not repugnant to natural justice, equity, and good conscience, and which is not contrary to public policy? or which is not contrary to any law for the time being force. So the basis of the decision was very erroneous. It was a misunderstanding of the nature of the conflict. The conflict in that case was not an internal conflict because there was a foreign element. And so what the judge should have learned is what is the conflict of law rule to determine validity of a marriage done in Nigeria between a person domiciled in Portugal and a Nigerian citizen. The fact that the marriage is polygamous does not offer a free answer, an easy answer, because the validity of a polygamous marriage is also determined by the same formula of the validity of a monogamous marriage. What is the formula? The formula is as to capacity, law of the place of domicile. As to formality, law of the place of celebration. So if the court had applied the relevant connecting factor in the field of international dimension, the answer would have been different. Because the court would have found that a polygamous marriage celebrated in Nigeria, as far as the question of form is concerned, cannot be invalid because Nigerian law permits polygamy. The other question is, as far as capacity is concerned. So the question of capacity would have meant the wife is domiciled in Nigeria. Does Nigerian law permit a woman to marry under polygamous marriage? Answer is yes. The next question will be the husband domiciled in Portugal. Does Portuguese law, his personal law, does it permit him to marry a woman under a polygamous marriage? The answer to that question is not straightforward. It's not as straightforward as you think. Okay? Yes, Portuguese law does not permit polygamy. But there's a distinction between potentially polygamous marriage and actual polygamy. So we would have answered our question. We will have further question. If the form is polygamous, but the man is taking the woman as a first and an only wife, he has not violated his domiciliary law. He has not violated his domiciliary law. So an English court applying English conflict of law rules would have validated the marriage. Okay? There is a case I normally cite. Hussein and Hussein. Hussein and Hussein. Hussein and Hussein was the case where an Arab who was domiciled in England entered into a polygamous marriage with a Pakistani. Okay? And before the English court, the question was, what is the status of that marriage? The English court held that the marriage, for all intent and purpose, as far as England is concerned, was a monogamous marriage. in its form as polygamous marriage, it was done in Pakistan, which law allows it. So that's a non-issue. But the question of capacity, I'm saying the English court said that as far as the question of capacity is concerned, the marriage was a potentially polygamous marriage, not an actually polygamous marriage. But for purpose of English internal law, it will be treated as a monogamous marriage because, one, the wife who was domiciled in Pakistan, even under Islamic law, cannot take a second husband during the pendency of the marriage. Then the husband, as far as the husband is concerned, even though the marriage was polygamous in form, it is monogamous because it is his only marriage. Forbidding an English domiciliary from polygamy simply means forbidding the male spouse who is domiciled in England from taking a second wife. In Fonseca and Passman, nobody even asked any question. We didn't even want to know whether our girl was his only wife. Can you imagine? A man came to your country, married your daughter because you threw up for him your custom. He married your daughter under your custom. Even though his own law forbid him from doing polygamy, there's no evidence that he took his second wife or that he had another wife at the time he was marrying your daughter. And yet you are very quick to dismiss the marriage, invalidate. What people are we? You check for, how many people are hearing me?
Yes, we are, sir.
Yes, sir.
You read that judgment and see what was their reason for that judgment. You find that there is no reason other than displaying lack of understanding of this subject area. So, what is the most important issue? One, the case was not an internal conflict of law case because there was a foreign element. It is true that we have provisions that regulate internal conflict and talk about transactions between natives and non-natives. But that is where the requirement of foreign element is not there. When there's a marriage relationship between a Nigerian and a non-Nigerian, that is an international conflict of law issue. It's not an internal conflict of law issue. And if we only understand how the colonial masters themselves who brought this whole idea, how they tackled the issue, we'll be better off. Look at the issue of Islamic law. I find it very funny that in year 2025, an attorney general is still going to press saying that Islamic law is not cannot be applied in Nigerian courts. Why are they saying that? They are saying that because the Muslims themselves do not understand our constitution very well. the way to treat Islamic law, the worst case scenario of treating Islamic law is to treat it as foreign law. And what do our High Court laws say? Apart from the Constitution giving the State High Court unlimited jurisdiction, you will find sections in our High Court laws that say our High Court should do as the English court will do. And it is those provisions that we have used to show that if a matter has a foreign element, with the likelihood that foreign law will apply, it is the High Court that you go. So I will illustrate this by telling people that forget about Islamic law. Because Islamic law divides us because we are either Christian or Muslim. I will be surprised if a conflict of law student in your class will tell me that two Jews cannot have their marriage litigated upon in the State High Court. Simply because Jewish law is not a local law. If it is not a local law, then it is a foreign law. What do they have to do? Plead and prove. Plead and prove. We just finish it now. Plead and prove. The person who wants Jewish law to apply to the marriage will plead it. We prove it. We call a witness. So if two Jews can have their matter litigated in the State High Court on the basis of the provisions of the Constitution that gives State High Court unlimited jurisdiction and the other provisions that say they will exercise jurisdiction concurrent with the English court, why we two persons who say that the governing law of their dispute is Islamic law, why will somebody say they don't have any court in Nigeria to entertain their matter? I have been of the view that the Muslims shot themselves in the leg by asking for one stupid Sharia court of appeal. If they had understood the jurisdiction, the extent of the jurisdiction of the State High Court, what they should have done is to have experts in Islamic law that will be proving the position of Islamic law on disputes governed by Islamic law. And let's see a State High Court say it cannot entertain the matter. So that type of reasoning is what led to Fonseca and Passman. A State High Court was entertaining the matter, then called Supreme Court, but it allowed itself to be guided by the personal jurisdiction of the customary courts. It is the personal jurisdiction of the customary court that is limited to natives. There are good reasons why the legislature would have done that. Customary courts are presided over by non-lawyers. And you don't want them to mess up foreigners. But the State High Court is presided over by judges who are learned in law, including conflict of laws. Even if the law is foreign and they don't know, they know what they should do. They know that they will need the law to be pleaded and to be proven before they give judgment. So the bottom line is that we need to understand when the conflict is internal. For the conflict to be internal, there must be no foreign element. You must be talking about two Nigerians, two residents of the place where the action is taken. But the issue really is that on the dispute, there are more than one system of law. And I told you that when we have legal pluralism, which is when we say there are more than one system of law, there are always one or of 3 questions that the court will always be faced with. The first one is amenability. How do I say A is amenable to law A and B is amenable to law B? Some of the time it is pretty straightforward. If the dispute is between an EFIC and an IBIBIO, you know that the EFIC man will be governed by customary law of EFIC and the customary law of IBIBIO. But what of if the matter is between 2 Muslims, one preferring customary law and the other preferring Islamic law? A Muslim native is equally amenable to both. And so the judge will have to go through a lot of personal tests to determine that it is Islamic law that ought to govern or it is customary law. So those are questions of amenability. Okay? Then you have question of change. If a person was amenable to, say, Ijesha customary law before marriage, but he marries under Benin customary law, or lived in Benin and all of that, when will the court agree that he has become amenable to another system of customary law, or he has become amenable to the general law? As for example, 2 people marry under customary law, the next day they go to the registry. We call it double-decker marriage. That is the question of change. It's the question of change. They have converted, they have mutated that their marriage from one governed by customary law to one governed by the act. And the incident of that marriage will subsequently become regulated by the 2 pieces of legislation on the matter. They cannot say, but we did native law and custom. Okay? They have opted out of customary law the moment they went to the registry. So that is the second question, the question of change. Then the third one that will usually happen when you have legal pluralism is, it's not a question of change, it's a question of determining applicable law. A was amenable to law A, B amenable to law B. They enter into a transaction without either of them having to change. If there is a dispute in the relationship, which one are you going to pick to choose to govern the relationship? That is the one, that is the only one that our High Court laws attempted to regulate, and they regulated it also in an uninformed manner. Why do I say uninformed manner? They kept talking about transaction. And Obilade asked, if the question is, who will inherit the property of Mr. A? So which transaction are you talking about? If B and C are fighting over inheritance of property of Mr. A, where does transaction come in? In most of the subject areas, where dispute will come, the dispute will be a status dispute. And you can't call a status dispute a transaction. Status subjects begin from marriage to legitimacy, legitimation, succession. All of them are status issue. So the legislature, in drafting the High Court laws, left the main issue out and was governing the small matter of A buying something from B, whether it will be governed by English law or customary law, or A who is subject to a BBO custom, buying something from B who is subject to EFIC custom, and determining the question of whether it is EFIC custom or a BBO custom that will govern. Those provisions are never good enough for status relationship. And the legal system text writers also recognize it. So those are the three questions. Those are the three questions that you would always, one of them will always come up when you are talking of legal pluralism. The first one, amenability. Who is amenable to what? Professor Olaniyan is a Yoruba Muslim. Which one is going to govern his intestacy? Is it Yoruba customary law or is it Islamic law? That's amenability. Change. Professor Olaniyan, though a Yoruba Muslim, married his wife under the Marriage Act. Anybody who is married under the Marriage Act, his intestacy is governed by Administration of Estate Law. So that's the question of opting out or change. Though it would have been governed by Islamic or customary law, the manner of his marriage meant that he has opted out of his Islamic or customary law possibility, and his intestacy is now going to be governed by the statute. That's change. Whereas the third one is he enters into a relationship with somebody who is not a Muslim or a Yoruba. Can he insist that his Islamic law or his customary law will govern the relationship? That's the third issue. Those are the issues that will always arise. Okay? So all of you should go and look at Fonseca and Passman, and you'll be able to criticize it from a conflict of laws perspective. Okay? My take is that it was not an internal conflict of law issue because the same foreign elements that our own conflict rules will require us to identify that there is international conflict of laws did occur in that case. The internal conflict case is a case that everything about it is Nigerian. Once there is a foreign element, it's not internal again. It is something else. But the legal system teachers believe that once it happened in Nigeria and the Nigerian court decided it is an internal conflict case. That is not correct. The fact that the marriage is done in Nigeria does not mean that Nigerian law will govern the capacity of the couple. Yes, Nigerian law, if the marriage was done in Nigeria, Nigerian law will govern form. But as regards capacity, it is the law of the place of domicile that will govern. And once you have that type of situation, you cannot treat the matter as an internal conflict of laws matter. Okay? Is it clear? Hello?
Yes, sir, it's clear.
Yes, sir.
Yes, sir.
Yes, sir.
Sir,
It's a bit technical, but you have
just
to
a quick
understand
question,
it.
sir.
Yes?
For my elementary, knowledge of constitutional law, I think we read materials those years that one of the anomalies of the Nigerian constitution is that there is a Sharia court of appeal without Sharia court of first instance. So my insight from your explanation now shows that it may not be an anomaly because the high courts, they have unlimited jurisdiction and they may be able to, apply laws
or foreign laws that would have been applied by the Court of England.
Yes. Yes. You see, but the Sharia Court of Appeal cannot take appeal from my court now. It's of the same coordinate jurisdiction. Do you understand? With the High Court. We in Nigeria, I don't know how to describe us. What do I say? We behave like we are too paternalistic in behavior. The Muslims want to see that the state recognize them. The Christians want to see that the state recognize them. Everybody wants to. The traditional worshippers want to see that. If any two persons have a dispute, and that dispute is governed by either existing or foreign law, there must be a court to entertain the matter. There must be a court to entertain the matter. If the governing law is not known to the judge, they plead and prove the foreign law. Even customary law, when you go before state high court and judges are not empowered, they do not know customary law. Can you imagine a situation where inheritance is the issue before a state high court, and it is assumed that the property is family property and is going to be governed by customary law? Can you imagine the state high court saying, because it's governed by customary law and all I have learned in the law school is English law, I cannot entertain the matter? Is it not that you come and prove the customary law before him? Is it not one of the things we learned in legal system, that you must prove customary law unless it is judicially noticed? So what stops somebody from proving Islamic law? That somebody is saying you must have special court. Then now you want to have a arbitration panel. A lawyer, a trained lawyer, is saying that because it is Islamic law, you cannot have arbitration panel. They are even arguing that because you already have customary court, and a customary court can entertain Islamic law and all of that. So the Arbitration and Conciliation Act of 2023, the only local dispute you can take before an arbitrator is the one that you don't have court to entertain. Is that so? Is it because we do not have court that will litigate matters that we have Arbitration and Conciliation Act permitting people to set up arbitration? No, we must struggle to understand the law better. We must struggle to understand the law better. For me, and when I have opportunity to do it before Muslim audience, I will tell them that what is happening in Lagos, where you have Sharia arbitration panel, is better than what is happening in the north. Because then you have the genuine experts. They will give their ruling based on Islamic law. And the role of the High Court, which will save them from the burden of proving and pleading, is to perform the function of a lex arbitri on their watch. In other words, if the two Muslims who have gone to Sharia arbitration panel for any reason are not satisfied, one may be challenging, the other may be seeking enforcement. That saves the High Court from the burden of going into the law it doesn't know. The only reason why the High Court might have a problem is because it doesn't know Islamic law. The judge does not know Islamic law. And the worst case scenario is you treat Islamic law the way you treat Jewish law. a foreign law. And the person who wants to rely on it, if he truly wants to rely on it, will have the body of pleading and proving it. But once you have gone through arbitration, all of that will be done before an arbitral panel that consists of an expert that knows the law. And the role of the High Court will be either to exercise one of the powers that they usually have upon challenge of the conduct of the arbitrator or whatever, or to register the award. As far back as 1914, the colonial administrator of Lagos told Muslims that that was the way to go when they complained to him that they need court, they need all of that. And he told them, you don't need court. What you need is to trust yourself. Appoint arbitrators amongst you. You are the one who know this your law. We don't know it. Once your arbitrator gives an award, our own will be to register it. That's as far back as 1914. The colonial administrator told them that. Today we are still arguing whether there's any court to entertain Islamic law or whatever. When you have court that will entertain Japanese law, that's the question I ask. That suppose the dispute requires application of Japanese law, are you going to look for validation from the Constitution? Our people will then cite Section 277. They will cite Section 277 and say Section 277. Section 277 is talking about jurisdiction of the Sharia Court of Appeal, just like the relevant section of the customary court law, which is talking about personal jurisdiction of the customary court. For God's sake, how can you bring that one into the jurisdiction of the state high court that the same constitution says is unlimited? So if Section 277 limits the jurisdiction of the Sharia Court of Appeal, is there any logical reason to extend that to the state high court? In fact, that Section 277 limits the jurisdiction of the Sharia Court of Appeal is a ground for the Muslims to know that they didn't follow the correct approach. If somebody has cancelled them that, look, there is no matter that the state high court cannot entertain. You cannot limit the jurisdiction of the state high court because the law it will have to apply is foreign. Okay, when we get to second semester and we are doing jurisdiction, you will see cases, plethora of cases on the issue, where somebody thought that because Israeli law was going to be the governing law of a dispute, therefore, he didn't have jurisdiction. And the Court of Appeal told him that, have you not looked at what the High Court law says? It says you can exercise all powers, authority, and jurisdiction that the High Court of Justice in England can exercise. Even if that provision of the High Court law is not there, how do you construe Section 236 or 272, 236, 1979, 272, 1999 of the Constitution that confers on the State High Court unlimited jurisdiction? What is the meaning of unlimited? The cases have explained it. Unlimited simply means that as far as original jurisdiction is concerned, you share concurrent jurisdiction with any other court. Even when the law has specifically vested jurisdiction on that court, you also have it. And logically, the meaning is that even the one that law has not bothered to stay, this is where you will go, it is your court they will come. You look at section 272 of the Constitution, compare it with the provisions of the other provisions of the Constitution spelling out jurisdiction of the other court. You see that those ones will list. They will give you an extensive list. The meaning is that they want you to apply expressio unis exclusio or terror's rule. But in the data of the state high court, they don't even give you any idea. They say any right, any privilege, anything, any whatever. No subject matter is listed. You have a court with that type of wide jurisdiction, and you are still asking yourself that because a foreigner has married a Nigerian native, there's no court to go. So those are the issues. Can we go to international dimension now? There's no way we can finish marriage in one lecture. What I will just take note of is whatever we have done, that we examine. Because you cannot do an exam without examining marriage. Oh, yeah. Let's go to international dimension now. Hello?
Hello, sir.
Who will present international dimension? Hello?
Hello, Prof.
Yes.
Yes.
International dimension. Go to international dimension.
Okay, that's part 3 of our presentation. Oh.
Go. What did you say there?
Yes, under that we are looking at what a validity of marriage entails. And then in examining that, we looked at it from 2 perspectives. Which are the formal validity and the essential validity of marriage.
Good.
So under formal validity, formal validity of marriage is governed by the law of the place of celebration. So which is known as a lex loci celebrationis.
Yes.
So yes, sir. So what this means is that where the marriage complies with the requirements pertaining to marriage in the area where that marriage is celebrated, it will be valid, irrespective of the fact that it may be invalid in the law where the parties are from or where they are domiciled. So we looked at the case of Bethium versus Datus. So in that case, 2 Russian Catholics who were resident in Quebec, in Canada, they were married in a Catholic church in France. So the priest who officiated that marriage inadvertently omitted to conduct a civil ceremony. So as a result of that,
I'm not hearing you again. No.
that as a result of the French law. So I was looking at the case of Bethium versus
Yes, let me
Datus.
come to that point.
Yes, sir. It said it involved the marriage of 2 Russian Catholics residents in Quebec.
Yes. Don't know what is happening. I'm not hearing, no.
Hello, class. So, please, sorry, I was logged out. The network
Yeah,
is.
we can hear you. You're back. We can hear you.
Yeah. Thank you. Sorry for the interruption. So, Lord John Dean stated in his judgment that there is, if there is one question better settled than any other in international law, that it is as regards marriage. Now, putting aside the question of capacity, if a marriage is good by the laws of the country where it is effected, that marriage will be good all over the world, no matter whether the proceeding or ceremony which constituted the marriage, according to the law of the place or proceeding, okay, or would not constitute marriage in the country of the domicile of one or the other spouse.
Sorry, I think Prof is not online now.
Okay, Prof has been logged out too.
Yes.
Network is a bit terrible. Maybe we should wait for Prof. Okay.
Hello, I'm online.
Welcome back, sir.
I've been present always.
Okay,
I've been present. I was hearing you. You
okay,
are telling us what the court held in that stores, that stores case. Yes. And I think we have understood what you are saying.
Yes, sir. Yes, sir.
You are telling us the court says.
Yes, sir.
Listen
Thank
to
you,
me.
sir.
You are telling us that the court said if a marriage is celebrated in a place according to the law of the place, that marriage will be valid everywhere, notwithstanding that the form followed might not have complied with the form prescribed by the law of the place of domicile of both or either of the spouse. Is that also?
Yes, sir. It is, sir.
Okay.
Yes, sir.
Go on.
Okay, sir. So the same follows. Even in a country where proxy marriages are recognized. So, like for instance, in the case of apt and apt, so a marriage was celebrated by proxy in Argentina. So between a man and woman who were resident in Argentina and England respectively. So that marriage was upheld since the Argentinian law considered such marriages valid. So another issue, a very dicey area in this aspect of formal validity of marriage is when it comes to parental consent. So the question has been, is parental consent is it a formal validity or is it
Is it a question of form or a question of capacity?
Yes, sir. So
what is the position of our conflict of laws?
Yes, sir. The position now of our conflict of laws. That we follow England. We follow England.
Of course. When I say our conflict of laws, I know we have no original idea. I'm talking about England.
Yes,
what is the position of our conflict of laws?
Our conflict of laws.
How do we treat parental consent?
For parental consent is a form. Is a formal validity in England.
Why? What explanation have the textbooks given for why parental consent is a question of form?
Okay.
What explanation have they given? Did you read any textbook on the issue?
Yes, sir. I combed up some textbooks on that area, sir.
Okay, let me help you.
Okay, sir.
You know, some of these issues, you cannot understand them very well unless you understand our internal marriage laws too. For example, in Nigeria, the question of form you will find under the Marriage Act. Do you understand? Most of the requirements for a formal monogamous marriage, you will find under the Marriage Act. So in England, they have a particular statute that they call Lord Hardwicke Act, Lord Hardwicke Statute. Everything that is regulated there is considered by conflict experts as question of form. And so it is there that the question of parental consent was regulated. And it was provided there that you would need parental consent if you haven't attained a certain age. But after attaining a certain age, I can't remember the age now. After attaining a certain age, parental consent is not compulsory. Okay?
Yes,
but
sir.
Around England, especially in Scotland, they did not even, their own law does not even require parental consent at all. So you will find their children who have attained the age of, age of marriage is different from age of majority. Age of majority was 18. But children were permitted to marry once they have attained the age of, I think, 15 or so. So you find children who have attained the age of 15 or 16, but who know that their parents will say, no, you are still too young to marry. Okay? And they don't want to give a damn about their parents' position. So they would then travel to Scotland over a weekend, get somebody to solemnize them as a man and woman, man and wife, and they will come back by Monday. And so whenever such a relationship now broke down, the one who should go for divorce will instead go for a nullity, saying that the marriage was never valid in the first instance anyway, because as at the time we did the marriage, our respective ages was 15. And so we needed parental consent. I have not attained maybe 18 or 21, which is the age of majority. But we didn't obtain it. The other party will say, then the English court will tell them that, where did you do the marriage? You say they did the marriage in Scotland. And the English court will then tell them that parental consent is a formal validity requirement. And once there's a foreign element, you see how people who understand conflict of laws, how they decide cases. Once there's a foreign element, it is the place where you celebrate that will determine whether you needed parental consent or not. And upon checking the Scottish law, it is discovered you never needed parental consent. So that marriage is formally valid. Even though the English internal law would have said the marriage was not valid because you didn't obtain parental consent, because the English conflict rules categorizes parental consent as a question of form governed by lex loci celebrationis, and you have celebrated the marriage in Scotland where that requirement is not sacrosanct, your marriage is valid. So that is the story. That is the beautiful story around parental consent. Then you now have cases. You have cases like there are cases of French law too. French law too had our own dimension of the matter too. French law had a higher age for parental consent. They say that be 25 or something and all of that. Higher
Yes, sir.
age than England. So you
25.
find French people, Simone and Malak is the case I'm talking about. You find French couple, they have already attained age of majority, but they have not attained the French age to do away with parental consent. But they will come to England and they will marry. Okay? In one such case, the question was whether the marriage was valid. Okay? The English court held that as far as parental consent is concerned, by the English conflict rules, it's a question of form. It is governed by Lex Loci Celebrationis. And since the marriage was celebrated in England, and the prescribed age for you not to require consent in England is 21, the fact that they had attained 21 has qualified them, notwithstanding that the law of the place of domiciliary, which is French law, will say that they have not attained the relevant age. So that is how the English cases settled the question of parental consent as a question of form. But Facebook will spend some time on it because it looks a bit funny. You would think ordinarily that parental consent should be a very important requirement. In some system of marriage, in Islamic law, for example, it's an important thing. Wali is absolutely important. But our own internal law, at least for monogamous marriage, our own internal law requires it, categorizes it as a mere question of form. And so, if you want to avoid parental consent, just go to a country where the law is a bit slack on the issue, and give yourself a ring and come back. We must recognize you as married, following the English position. Okay? What are the other questions? What are the other issues under form?
Yes, sir. The other issue
under form.
Yes, another issue under form is where, for instance, the marriage is formally recognized as formally valid under one system or one country, and then it's recognized as invalid under another country. So what will courts do in such a situation? The court of the...
No, that's not what I'm asking you. What are the substantive questions that will be categorized as form? You have given us the question of possibility of marrying by proxy. You have given us the question of whether there's...
Okay, sir.
The need for a civil secretary. Okay. The place of the marriage.
Yes,
the
sir.
Time.
Yes, sir.
Yes, sir. Publication of bans.
Yes, sir.
Sorry, let me pick this call.
Okay.
Hello? Okay. Let's go on.
Yes, sir.
Hello?
Okay.
Those are the questions of form.
Okay. Under the questions
Do you
of form,
understand?
sir. Yes.
Okay. So, what are you trying to say?
Okay. Under the questions of form, we also mentioned that the other matters that can come up are the number of witnesses required,
Yes.
and the hours during which the marriage can be celebrated.
Whether the certificate must be signed.
Yes, sir.
Whether a certificate must be issued, whether it must be signed, all of this is a question of form. And
Yes,
it is only the law of the place of celebration that we will look up to determine the validity of marriage as far as those questions are concerned. So let's move to capacity now. Oh,
yes,
okay,
sir.
before we move to capacity,
Yes.
You have told us that the general rule is lex logis celebrationis. Are there exceptions?
Yes, sir, there are. And
Yes.
in order to examine this exception, you know, when you were teaching us the doctrine of Rouvroy, so you made mention of different approaches like partial acceptance of Rouvroy or rejection of Rouvroy.
That's not what I mean. That's not what I mean. Are there circumstances where, notwithstanding that you have violated the law of the place of marriage, nevertheless, Anglo-Nigerian law will say the marriage is still valid? That's what I mean by exception.
Yes, sir, there are.
Yes, what are those exceptions? What are those circumstances where there may have been a breach?
Yes, sir, where the use of the local form is impossible.
Yes.
That is one. Yes, sir.
Then
also where the marriages in countries under belligerent application.
Good.
Yeah. Then marriages of members of His Majesty's forces serving abroad.
Good.
So, and then we also have instances of marriages under the Foreign Marriage Act of 1982, sir. Yes, sir.
That one is English law. We also have equivalent statute in Nigeria anyway. Then we have marriage in foreign embassy.
Yes, sir.
Please, I cannot hear Prof. I don't know what's happening, but I can't hear Prof at all.
Marriage in foreign embassy. That is Nigerian embassy abroad. You go and marry there.
It should be on network. I can hear him clearly.
Okay.
Maybe you log out and log in again.
You know what we are going to do?
Okay.
I have to leave now. I will send you a slide. I will send you a slide that I've done on marriage because there are still several topics left. But when I want to examine you, I will stop where we stopped.
Yes, sir.
Do you understand?
Yes, sir.
So we stop on lex logis celebrationis and exceptions to lex logis celebrationis. But you need to know more than that. You need to know the question of capacity. Okay? You need to know the question of what do they call it? The question of recognition of foreign divorce decrees. Okay? So I will send you a slide. I will send you a slide so that you can use it to revise your seminar paper and whatever text you are reading so as to understand the thing. But for purpose of exam, this question of internal conflict as opposed to international conflict, the question of formality, what issues come under formality, and whether there are exceptions, and the implication of the rule lex logis celebrationis. That's where I will limit my question. So on that note, please allow me to go. I want to go and say my prayers. And I don't think I want to return to the class after prayers. Hello?
Okay,
We
sir.
can hear
Thank
you,
you so
sir.
much.
Thank
Thank
you,
you,
sir.
sir.
Okay.
Thank you, sir.
I will give you AOC. I will give you AOC on the other topics, but you have known what I will examine in marriage now. Okay?
Yes, sir. Yes,
Ah,
sir.
Yes.
This is up to where we stop.
Yes, sir.
Okay, I will give you AOC on the other one between now and say Wednesday.
Okay,
Thank
sir.
you, sir.
Thank you, Prof.
Sorry,
Yeah.
sir. Hello,
Thank you,
sir.
Prof.
Hello, sir.
Yes.
This is Joy, class rep. Does it mean we will not be taking topic 9, thoughts?
Hello?
Yes, sir. I was asking. topic.
What we are going to do for those of you who are doing thought is that
Yes, sir.
since we don't have time, are all of you going to be in the second semester?
I'm not sure of that,
with
Yes,
sir.
thought
sir.
in the second semester.
I'm not sure of.
We will examine your something. Okay, class captain. Hello, class captain.
Yes, sir.
Let me know how many of them
Yes,
are
sir. I can
present.
hear you, sir.
Let me know how many of the thought people are present so that we score them for
In class now.
presentation.
Okay,
You
sir.
take
Let me
that one
get
after
their
I've left.
names.
Take it after I've left.
Okay,
Take
sir.
their attendance after I've left so that we know those who will score mark for presentation. I will look at their paper
Okay,
and
sir.
give them some mark for the seminar itself. But
Okay, sir.
we will start with thought in the second semester.
Okay, sir.
We will start with thought in the second semester.
Okay, sir.
Okay.
Thank you, sir.
You're welcome.
Thank you, sir.
Yeah.
Yes, sir. Please, if you're in group 9, kindly hold on so that I can confirm those who are in class now as Prof has instructed. Let me get
Yes,
the name. Sorry, I'm trying to get the names. Okay, group 9, we have Oyerinde Temilade Tawakalitu. Is she in class? Eleo Kokuri, I'm sorry, AM.
I'm right here.
All right, ma'am. Alexander Sebastian.
Very present.
Temitope Rukayat.
Present, please.
All right, ma'am. Andrew Akinwale. Andrew Akinwale. Okay, I guess that's all. So I've noted those ones.
Michael.
Okay, Michael, yeah, you were adding class. Michael, okay.
Michael
Noted.
Igwebiki.
Okay, noted. All right. Thank you, everyone. Have a nice day. If you've not
So
dropped
how
your
do we
name,
submit, Miss Joy?
okay,
Do
do
we
you mean the hard
submit,
copy?
I'm sorry?
Do you mean the hard copy of your work?
Yeah, that's what I'm asking. Do we need to submit a hard copy?
Yes, please.
Because we've broken down into subgroups. So should each subgroup submit their hard copies?
No, we submit as a group.
You have to
Submit
submit
as
as a group,
one?
but I'll still confirm that from him. But ordinarily, it ought to be a group. But I'll confirm from him. Yeah.
Thank you. All right then.
Thank you, everyone. Have a nice day.
Thank you.
Yeah.
Thank you.
Bye. Thank you.
Ẹlẹ́dàá mi, nígbà tó ti dá mi sípò ẹrú.